Good afternoon, and on behalf of Forrest Solutions, welcome to part two of the series on return to office, vaccinations, and other strategies for return to office. My name is Anthony Davis. I'm the Chief Revenue Officer at Forrest Solutions. And for those of you who don't know, Forrest Solutions for nearly 50 years have provided companies and law firms of all sizes with people solutions and on-site outsourcing, direct hire, temporary, temp to hire, and consulting. A privately held, owner-led company known for our ability to remain nimble and our hospitality-grade customer service. I'm joined here today by Adam and Brendan. I'll let them introduce themselves, and then we'll get stuck into some questions for you guys.
So thank you, Anthony, and thank you, Forrest Solutions. Good afternoon at this point to everybody. As Anthony said, my name is Adam Gattell. I'm here with Brendan Sweeney. We're both employment litigators from Jackson Lewis. We're one of the largest labor and employment firms nationwide. We have about a little over 60 offices around the country, almost 1,000 attorneys, and we practice in all areas of employment law management side, meaning that we represent employers, and we help employers, whether it's through advice and counsel, or as Brendan and I frequently do, litigate, whether it's defending employers or enforcing restrictive covenants and things like that. And so from that experience, we're here to just share with you a little bit about what we've been seeing in the last couple of weeks and months about the transition for employers back to the office, making sure that employees are productive, sort of navigating those minefields having to do with the vaccine and other COVID issues. And, our time is short, but we'll try to squeeze in as much information as possible. As we discussed in the last session, this is really the continuation of that last session, two real big themes came out. One is, how do you get people back to the office? And the other is, can you enforce vaccination policies? What do you do with that? So we're here today to go through all of those issues and some of the things that Brendan in particular has been seeing lately with respect to competition by employees who now feel that they have the upper hand.
Right. Thank you, Adam. So do you want to start with a quick recap on where we ended up at the end of the part one? This is part two. So can you mandate people back to the office, and can you mandate people to get vaccinated?
Yeah, so yes, the answer to that is yes. You can mandate that. You can decide for your workplace what is the effective way to run your workplace, and can you return people back to the office and require them to do so? And really that question is, can an employer discipline or discharge an employee who refuses to return to the office, right? You want everyone back. They've been used to working remotely for the last 18 months. They say, hey, boss, this is fine. I've been even more productive. Look at my metrics. Do I have to come back? The answer is yes, if you choose to do so, unless the refusal triggers some sort of leave entitlement or potential reasonable accommodation. Any sort of, the tension is what's legal and what's going to help your business. You don't want to make an arbitrary decision just to bring people back for the heck of it because you feel like that's the way it should be. You have two issues. One, does someone have a legitimate health reason that they cannot physically be back in an office in a compromised environment? That's one issue. And the other is, what about morale? What about recruiting? This right now we are seeing, and Brendan can speak a little to this, about it's almost a buyer's market or a seller's market, depending upon how you want to look at it. If someone says, I don't really feel like coming back, and I've got 3 job offers where they're going to let me work remotely, so what are you going to let me do? That's not a legal question. That's a business decision. Brendan, any thought on that?
Yeah, I think just generally it's a different world that we're in. One thought is the EEOC has been fairly clear that just because a job could be performed remotely during the past year does not automatically mean that is a accommodation that an employer must provide. So, echoing what Adam said, if you have a business reason and you're applying the rules in a non-discriminatory way, you should be fine. But there is a building war for talent, which I think is only going to increase over time as employees know their value. They know where to find new opportunities, whether that's with a new employer or striking out on their own because they've realized some of the things they thought they needed, they don't really need. So I think there'll be a lot of activity in people trying to go their own way or trying to go, away from your company, possibly with your information.
Right. We'll get on to more of that a bit later on. But let's talk now about, so your employees are coming back to the office. You might be mandating a certain number of days, but the point is they're coming back to the office. So how do employees allow vaccinated employees to stop wearing masks? And can you have one rule for vaccinated employees and one rule for unvaccinated employees? And how do employers know?
Good question. The answer to all of that generally is yes, right? The states have now, or at least I'm talking about New York State, some other states leaped ahead of New York in this. Some others, are still holding back a little bit. But for the most part, the mask mandate on a legal level is going away. Assume you're in a state where there's no longer a requirement to wear a mask. You can then make a decision within the workspace that people who are vaccinated do not have to wear a mask. You are allowed to ask for whether or not someone is vaccinated. That is health information. You should protect that as you would with any other health information. You can even ask for copies of people's vaccination cards. But you want to be, first of all, underlying all of this is not advice. This is just sort of topic areas that we're discussing. If you're going to make a decision, you do want to discuss with legal counsel, whether it's us or your regular attorneys, in a setting of giving some advice. This is really not, we have to have that disclaimer that we're not giving advice, but the EEOC has said that you can ask for that information. There's some, I guess, again, practical concerns. If you are requiring, if you're going to start making that divide, unvaccinated people don't need to wear a mask, vaccinated people do, what's that going to do for morale in the workspace? Are you going to run into some political issues? Are you going to run into some health issues? It's a little clearer, it's a little better to have one size fits all. You can have a mandatory vaccine policy. And if you do that, then you would make exceptions for people for health or religious reasons. And in doing so, you'd have to have those people wear masks. You can certainly do that type of thing. I mean, first, you want to think of it this way. First, you want to confirm, are there any local laws or regulations that require masking, regardless of vaccine status? That's what I was talking about first. You want to look at those mandates, assuming there are none, then you can determine whether or not you can require proof of vaccination, ask about vaccination status, or establish any sort of mandatory rules, or let people do it on the honor system. It's really up to you. The other issue is if your business is open to the public. We're not talking about a locked office setting. Do you have members of the public walking into your office, whether it's for meetings or you're in a retail setting, whatever it is? You don't want to have two standards for the folks who are your customers or clients and a different standard for your employees. You got to be careful about isolating unvaccinated people or treating them differently, because even if the reason is permitted to do something like that because they're unvaccinated, is that employee going to identify some other sort of protected category where they say, hey, I'm being treated differently because of, and you find yourself, looking down the barrel of a discrimination lawsuit. Those are all things you want to consider in that context. There's no real clear yes or no answer. It's, you have to weigh what your concerns are.
So you touched on this a little bit earlier as well, but how do you handle pushback from employees who want to remain remote?
So again, that comes down to sort of the first question, right? What do you want to do with your workspace? Is it the type of office that you want to require everyone has to come back, or are you going to have a flexible workspace? I'd ask Brendan what his thoughts are on sort of that, mandate, depending upon the type of workspace and how that applies to employee morale and then some of the legal issues.
Yeah, I think so much of it is like so many other things in employment law. Do you have a good business reason for it? Now, you can mandate people returning to work because you generally think it's good for your business. You can certainly do that. And you can have different rules for different types of jobs. You can certainly decide that maybe a more administrative job is better to be performed in the office. You can decide that, your marketing people are just as productive or more productive if they're mostly remote. You can certainly do that. What you can't do is base that on any, factor other than a legitimate business reason. Obviously, if you'd want to protect yourself against a claim that, well, all the administrative people are women, all the marketing people are men, and the result is discriminatory. But if you have a good, legitimate business reason, you have significant discretion at this point, much more so than we had some time ago, to just set a rule, set it by job class, and be prepared to make exceptions for people with disability, pregnancy, those kinds of categories. So, similar to the things we've dealt with for many years, obviously in a whole new context, but you have, as an employer, quite a bit of discretion.
So as a follow-up to that, I think you've experienced this situation a couple of times recently as well, but you've got an employee who doesn't want to return, but they want you to fire them so that they get unemployment. Can you do that?
So every state is a little different. Unemployment is on a state by state. There's a lot in the press about, what the federal government did with the last, piece of legislation that enhanced unemployment benefits for a length of time and a dollar amount. That money then went to the states. So state unemployment is really managed on a state by state level. Some states are much more lenient about how they grant unemployment. Others are more incisive about, what information they're going to be looking for. New York, for example, to be denied unemployment, is a pretty high bar, or you say it's a low bar to get unemployment. You have to engage in gross misconduct, as is defined under the law, or resign, choose not to come back. And if an employer proves either one of those, then you can be denied benefits. Usually what happens is some information is requested from the State Department of Labor. When you apply for unemployment, if you, as the employee, give the wrong answer, you could be denied unemployment. But if you're granted unemployment and your employer believes that you're not entitled to it, they can challenge that grant of unemployment. So in a scenario where someone says, I'd rather just you fire me so I get my unemployment. Yeah, in that scenario, with the Department of Labor not knowing anything else, and someone gets terminated with or without cause, that doesn't really even matter. And they apply for unemployment, and the information provided is, yes, I was terminated from my job. They would be granted unemployment. However, if it's a scenario where you've got someone working remotely, and they say, I really don't want to go back to work. I want to keep working remotely. And let's take the first question. This is a workspace that is opened up completely. The requirement is that everyone is required back, absent some exception for health or religious reasons. And you're told as the employee, you have to come back to work, and you choose not to, so you get terminated for that reason. The employer, if they want to challenge your unemployment, would probably prevail, because the answer to the State Department of Labor is there was a job available for this person. That person was offered that job. That person chose not to come to the office to do the job, and that was the requirement of that job. And so even though they were terminated, it was essentially an abandonment or a rejection of that job offer. If the unemployment division is looking at those facts, they would likely deny unemployment.
I just, at this point, I just wanted to say to everybody in the audience, feel free to add questions in the chat, which we'll try to get to as we go along. And if it's anything like part one of this, the question sidetracked us all the way through, but that's great because that's what you want to talk about. But we're going to switch gears slightly now.
Before you do that, I see there is a question there that I think sort of touches on one of the first topics we've already.
Okay. I'm not seeing the question.
It's in the chat. I can read it. I see it. It says,
yeah, you go. You take it.
Is there an ADA confidentiality issue with the mask, no mask based on vaccination requirement? Because that's a punitive disclosure of sorts. Excellent point. It's an excellent point. You are permitted to collect vaccination information to the extent that it confirms whether or not someone has been vaccinated. And you should, the best practice for something like that is to treat it like other health information. You designate someone in the HR department to collect that information. It doesn't get disclosed to anyone else. But yes, if you see people in the workspace who are wearing masks and other people aren't, and the sort of conclusion is that, oh, maybe that's someone who's not vaccinated. That's not health information per se that's being disclosed. You just know that that person's wearing a mask. There are plenty of vaccinated people who still wear masks because they do it out of, the belief that it's the right thing to do, to be around other people, even if it's not required in the workspace. So in and of itself, it's not necessarily a disclosure. You should not advertise that someone is vaccinated and someone else is not vaccinated. If the only designation is that you see some people wearing masks, I don't believe it's going to be a problem.
Right.
Let me just say, Brendan, I didn't know if you had another view on that or.
Completely agree.
So well, when we talked about this next question a little earlier, it made me think I probably should have waited for my vaccine. But can employers incentivize employees to get vaccinated?
You want to take that one first, Brendan?
Sure. The simple answer is yes. And while you could consider mandating vaccines, it would seem, at least from what I've seen, that the more popular route is to incentivize vaccines. And obviously plenty of people are getting them without any incentives, but an employer is clearly permitted to offer incentives, again, with the caveat that people with disabilities and people with religious concerns, will trigger a duty to accommodate. And even within your incentive program, you have to, work with counsel to make sure you understand those accommodation duties, because in some ways, the accommodations, the exceptions can swallow up the rule. But that's where I think a lot of the risk is. You're clearly allowed to incentivize vaccines, but you must deal with the people who are going to request an accommodation, which, if you're an employer of any size, is almost inevitably going to happen. And in those, you may even have to give the incentive to somebody who has a disability and can establish it. But your real obligation is to engage with them and to understand what they're requesting and why. And then, as I said, work with counsel. But the general answer is incentives are permitted.
And just for clarity, and maybe you can't disclose all of this, but what do we mean by incentives?
Well, I've seen gift cards. I've seen an extra PTO day, things like that.
Is that the PTO day to go and get your vaccine, or is
not necessarily? It's a day to yourself. And be aware that several states, including New York, do have requirements for paid time off to actually get the vaccine. So there's another obligation. You may have to both allow the paid time off and then give an incentive of an extra day off if you really are, and I think we're seeing this more in the service industries with people who are client facing, who really need a vaccinated workforce to make their customers feel comfortable. But we're seeing it in a number of industries.
I can tell you on that front, I've actually seen anecdotally on two coasts, on the West Coast and the East Coast, issues with healthcare employers where it was a client or patient driven issue with respect to the vaccination, that they wanted to know, that they were going into a setting where the people who were servicing them or treating them were vaccinated, right? And so what you can't do is you can't disclose individuals' vaccination status to your customers or clients. That's all fraud with all sorts of issues. But you can let the general public know, we're generally encouraging or we're generally mandating vaccinations in this workspace. Because I will tell you that it seems to be something that's going to be market driven, right? You're going to have customers, patients, clients who want to know the answer to that question, regardless of what's going on internally at your business.
Right. So there's another question come in. Adam, I think I don't know if it's a question or a comment, but in Boston, we asked employees to come back without a mask if vaccinated, in line with the CDC guidance released. Employee pushed back is that they do not trust the honor system and are asking us to consider requiring proof for either one, only those vaccinated coming in, or two, if not proof of vaccination, the unvaccinated employee has to come back only if wearing a mask.
So that's a sort of an example of what we were discussing earlier. You can do those things. You can require proof of vaccination, and you can make exceptions for people who have a reason not to get vaccinated. The sort of middle ground that what that person described with the pushback, that's obviously fraught with some issues. The mandating a vaccine is also fraught with some issues. Just today, before this started, I had a client, who was wrestling with an employee who basically gave them a reason that they're not getting vaccinated, and saying this doctor and that doctor told them not to do it, and was not giving a doctor's note, then ultimately did give a doctor's note. And this was a client that has a mandatory policy. Maybe the middle ground is, and this is a little untested yet, is you keep your sort of employee safety protocols in place. You say, look, we want people wearing masks. We want social distancing. We want, we're going to keep the area clean. If you're in your office or you're in a separated cubicle, you don't have to wear a mask. And you don't even get into whether or not someone's vaccinated or unvaccinated, because my guess, this is a pure guess or prediction, is that as we go through the summer, a lot of the mandates, everything's just going to sort of fall away in the natural course. Whether or not someone's vaccinated or not, I don't think is going to govern the workplace. This is just my own prediction. It's going to be the infection rate. If everyone remembers last summer, the infection rate was pretty low, at least in the Northeast. If we see that, we're seeing that now, and I think that's going to govern a lot of the behavior and the conduct. Whether it's in the workspace or in the public area, whether retail or sporting events and things like that.
Yeah.
So I guess my advice is then, well, again, not legal advice, is just wait a little bit. Before you start removing, certain rules or changing rules. I think they're going to change on their own.
Right. Okay, so switching gears slightly, with as we talked about before, it's fast becoming a candidates market, and we will inevitably see an increase in churn of employees as offering flexibility becomes an actual perk, becomes an actual benefit. And then as a result, I think we're going to see more and more people working longer and longer remotely. So how do we protect? How do we continue to and improve the protection of confidential information with employees working remotely for so long?
Brendan, why don't you jump on that first?
Yeah, and I think we're in a pretty extraordinary time for this, as many people were not mobile for a while in jobs, and there's surveys out there about the incredible number of people who will consider changing jobs in the near future. And anytime that happens, there's a risk that that person is going to try to is going to try to unfairly compete with their former employer. And the thing that I think is very obvious from people like for myself and Adam who litigate these things is your outcome is going to depend on how prepared you are. And if you're preparing, if you're dealing with it for the first time when that valuable salesperson resigns on Friday afternoon and is rating your customers, it's too late. So preparation in this area is key. And I think there's two main parts to that. One is having the right agreement in place with your key employees. And many employers have agreements that haven't been touched in years. And I think that's a real mistake. These agreements have to be updated regularly. The law is changing regularly. The things that can give you advantages have changed or often evolve. And there are many things that an employer can do to give itself protection. The other thing is you must know in advance where your key information is, how it might be vulnerable. Obviously 99% of this is electronic, but understanding your systems, how people may access them, how they've been accessing them for the past year and change is really, really critical. And if you wait, the information may be exploited before you can even do anything. So we really encourage clients to think ahead on these things, plan. It's probably going to happen. It's, depending on your business, there's a good chance that a former employee is going to become one of the biggest threats to your business. It happens all the time. So I don't even have more on that.
Yeah, one thing that somewhat similar to what you said at the outset there is that with everyone being remote, a lot of people became mobile. So I've dealt in the last couple of weeks with a number of companies where they had a one-size-fits-all, non-compete, non-solicit agreement because the company is based in one jurisdiction or one state, and now they've got employees in 14 different states or 14 different jurisdictions. And as they've had issues with the departing employees, someone up and leaves, or someone stole some information, or someone's competing, enforcement of that agreement becomes a problem because it's no longer, you can no longer rely on the state in which the company is based. You may be trying to enforce that agreement in the state where the soon-to-be former employee is. Washington State, for example, has some penalty, and I don't practice in Washington State, but I learned this from one of my colleagues the other day. That will it's a mandatory like $5,000 penalty, and there's also the risk of attorney's fees and costs if you try to enforce a choice of venue clause or a choice of law clause that's not Washington State against an employee who's actually residing in Washington State. Obviously that in that case, the employer had a one-size-fits-all agreement, so we're maneuvering around what we need to do with that. One thing you want to consider is if you have people in different locations now, are your agreements up to speed to where those people are, in terms of getting the best enforcement, or is the agreement worthless at this point?
And just as an example of how important it is to have the right agreement, in the past year and change, I have litigated 2 different cases where we were pursuing employees who left their company and unfairly competed. Both cases had pretty strong evidence that the departing employee had taken a lot of information they were not entitled to take, and both resulted in litigation. One case eventually settled for a relatively modest amount because while we could prove that the employee stole information that he was not supposed to take, proving sometimes the damages from that can be very difficult, and you may be reluctant to drag in clients or whatever the situation may be. But in the other case, we had drafted the agreement a long time ago to include a provision that said if the employer had to go to court to enforce the agreement, the employer was entitled to recover its costs and attorney's fees. That case settled for a lot of money because the new employer knew it was in real trouble because there was clear evidence of taking of confidential information. But there was also the risk that they were going to be paying our attorney's fees for a very long time. So just an example of why it's important to, I think the phrase is pray for peace and keep the powder dry. Having the right agreement in place is essential to protecting yourself.
Mm. So I think what you're saying is we need to be ready for an increase in people changing companies.
Absolutely.
That's definitely the case. We're seeing anecdotally, we're seeing it right now. I don't know what's going to happen come September, as time goes on. It's an unusual market right now, but I think that is something you need to be prepared for. And as Brendan's saying, the best way to prepare for that is know where your people are, know how to protect your information, and know what agreements or documents you have in place, because chances are they probably need to be updated to account for everything that's happened in the last year.
Right. And it's an interesting one that came up in our own organization when we've allowed work from home or work from anywhere. Is it important to specify?
It specify whether it's work from home or work from anywhere.
Right.
No, that's a good point. I mean, the issue is, are you setting a low, what's expected? You need to set an expectation. If it doesn't matter, if people could be on vacation and, they're working from anywhere, it really doesn't matter. But you need to know where your employees are. I mean, as we've just been discussing, there is a restrictive covenant basis for that so that you have the right agreement in place. There's also tax implications of that. Are you managing payroll appropriately? If you have someone who was working in New York and living in New York and now is living in South Carolina, what happens in terms of, your requirement to manage the payroll of that employee? Are they considered a New York employee? Are they a North Carolina employee? We're not tax experts, but that's an accounting question. I had a case with an employee who left New York to go take care of a sick relative in another state, and essentially was no longer working in New York and wanted to take advantage of the New York paid family leave benefit. And that became an issue for that employee because they were no longer deemed to be working in New York and that benefit. So they didn't have access to that benefit.
Anthony, just one other thing I'll mention a little bit off the topic slightly, but just slightly. The other thing, while there's the risk of your employee leaving and taking your information and competing unfairly, there's also a lot of litigation risks that we're seeing increasing that is all pandemic related, and sometimes in ways you may not expect. And just an example of a case I saw filed recently, many organizations pay their salespeople in some way other than hourly, obviously some type of incentive payment or other things. And often that's fine from a wage and hour law perspective because there's an exemption in federal law and most state law for outside salespeople. So if you're an outside salesperson, you have a lot of flexibility. You can treat those people as exempt from overtime. Well, this litigation I saw filed recently said, well, yeah, they were outside salespeople before the pandemic, but they haven't been outside in a year. And if they're not outside, they're not exempt. And that employer, I think, probably has a fairly big problem because the reality is they're not outside. And one thing, I've been doing this for about 25 years, about half of that time was in-house for a very large company. And one thing we put in place was a dispute resolution agreement, absolutely essential. It often has a class action waiver. So if you have an issue with one outside salesperson who's not really outside, you can manage that issue. If you have a class action, you have a much bigger problem. So just to mention that dispute resolution agreements are a very, very important thing. An employer can do a great deal to protect themselves by being proactive, whether it's a class action waiver or an arbitration agreement or a jury waiver, but there's a variety of things that can be done to better position your company if you're sued.
Brendan, I got a question on that. Just as I was talking about with the restrictive covenants, if you've got a dispute resolution agreement, essentially an arbitration agreement that requires any dispute to go to arbitration and keep it out of court, and you've got a remote workforce where people are now scattered to the wind, can you require that arbitration take place? Let's say you're a New York company in New York, or are you then bound? Does that then become a problem for you as the employer? You're going to have to go do an arbitration, in whatever state that employee is in.
Right. It's often going to end up that arbitration would be conducted wherever the employee last worked. You can try to work around that in your agreement, but there's quite a bit of deference to the employee on those issues, and that employee is probably going to get to bring their claim where they work.
Interesting. So here's another one, follow-on question from this. By the way, there's a couple of questions in the chat about vaccinations. So we'll come back to that in a second. But one of the challenges of having everybody remote for so long is that you start to suspect that they are going to quit, but they've been not been in the office for such a long time. How do you deal with that?
It again comes down to consistency and how do you manage your workforce. If people are using company devices and your IT people can track, when people are working or not working, The best thing to do is to expect, to manage people to do the work that they need to do. Is it showing up for remote meetings, at 9 o'clock every day or what have you? You can find out, if someone's working or not. And if all of a sudden you find out I had this just in another case where they believed that someone was working and just sort of stopped showing up remotely and had another job. You have a right as an employer to take action on that. It's not illegal to have two jobs, but it is certainly, you do not need to tolerate someone who's being paid by you and then spending that time working for someone else to draw two salaries, right? That's theft of time. There's nothing wrong with someone who works for you 9 to 5 and decides to have a job after, from 5 to 10 at night, unless you have a no moonlighting policy, which is something that's also lawful that you can do, depending upon the state. So it really depends on what you want to do. A lot of times with employee issues, you can manage so much with policies, you can manage so much with requiring people to check in and tracking information. But at the end of the day, you almost have to allow the bad conduct to take place, but then you have the right to terminate. That's really your remedy.
And again, be very careful about wage and hour litigation risk. So in that example, if you're able to, from your technology, tell that your salaried employee is really only working 3 out of 5 days, don't dock their pay. If they work 3 out of 5 days, they're entitled to their salary for that week. You can address it as a performance issue for sure, but don't dock their pay. Docking pay is almost never permitted. And just another thought on that, having two jobs is one thing. I had a situation recently where a client had an employee who was working remotely and would regularly bring a 6-month-old baby to the virtual meetings. Now, I know we're all coming out of that, but we'll still be doing a lot of virtual meetings. And the baby, who I have great sympathy for the mom, but the baby was not quiet. And it got to the point that the meetings basically couldn't happen because the baby was screaming and crying and the team members were complaining. And look, the reality is, while we all as employers want to accommodate people and that person was making it impossible for her to do her job and her team members to do their job. And of course, the employer was allowed to address that and say, that's just not acceptable behavior. Even though we're not in the office together, your responsibility is your job. And your job responsibilities while we can be flexible to a point, we have a right as an employer to expect performance. And I think everybody's going to be more flexible than they were a year and a half ago, but there are limits, and there are reasonable limits to that an employer can expect performance and, an environment where people can get things done.
Yeah, and that's why there are laws, paid family leave, the FMLA. People are entitled to accommodations and leave as necessary to address medical and family issues. But it's not an accommodation to, you can make a rule that meetings can only be attended by the employees, right? So it's not okay for someone to bring their child. It's not okay for someone to bring their best friend. It's not okay for someone to bring their dog. So that is not a discriminatory action to take.
Okay. So we have a couple, I think, similar questions in the chat. Adam, I don't know if you can take these on.
Let's see. First one I see here. Oh, do you want to read it?
Yeah. So we have cubed office spaces, and vaccinated don't have to wear masks, but vaccinated don't have to wear masks, but I guess it's unvaccinated do. Is this safe?
Well, it's whether it's safe or not is not for us to judge. It's certainly acceptable under the CDC guidance. Depending upon what state you're in, it also may not violate a mask mandate. A lot of the states have relieved their mask mandates, so you certainly can do that. The question is whether or not you want to do it, and you as the employer can set up that requirement that people, whether it's on the honor system or you're tracking vaccinations, this is something that, your employer is doing or the company is doing, and not running afoul of any guidance or law. Brendan and I are not the people to opine on whether or not this is safe. We're not virologists or epidemiologists, but it's sort of a confusing time right now. And our concern is whether or not, you're going to be violating any laws. This one does not.
So the CDC will allow this, but it's to be seen whether it's safe or not.
That's right. I mean, our guidance is you want to have a workspace. Again, it's a tension between, you don't want to get a lawsuit. And we saw these lawsuits early on in the pandemic. Someone was ill or actually passed away because they contracted COVID. And they said, aha, I got it in the workplace, or the estate is suing and saying you didn't have the proper policies and procedures in place. You want to have a safe workspace. And what does that look like? Are you taking reasonable precautions to make sure that the risk that the virus would be circulating within your workspace is low? And those are the things you want to consider. There have been Brendan, correct me if you know otherwise, but I think OSHA, they were considering having specific OSHA regulations and they never got around to doing it. So there's really, employers are sort of left, figuring things out on their own. And our view is you want to do what's going to avoid a risk that either people get sick because you don't want to get sued because of that, or two, it's going to disrupt your workspace. So keep people safe.
Right. And it comes back, I think the second question here is on the same vein. There's certain areas where there's visitors entering the office space, and these are marked regardless of vaccine status, but that's down to the discretion of the university, I guess.
Yeah, that's the same thing as you might as well treat it as a public retail establishment or any place where the public's come in. There's, whether a state has a mask mandate or not, the company can choose to have a mask mandate, a sign on the door that says, please, wear masks before entering, things like that. You can do that. The question is, if you are in a jurisdiction that is a particularly tense political environment and people are going to, get all upset because they're being forced to wear a mask, or they're going to get upset because people are refusing to wear a mask and other people do, there's nothing wrong with having that sign on the door. You walk into, name the large restaurant chain retail establishment right now in America, and there is a sign on the door that says, please wear a mask. If you're not wearing a mask, I don't think I've not seen anecdotally stories of people getting kicked out of stores. We saw that, months ago. But it's still a good practice to have in place for the safety reasons that I just described.
Yeah. So we're at the end of our 45 minutes. Brendan, Adam, thank you very much for your time today. And to everyone in the audience, we're going to send a follow-up, and there'll be a link to a survey that Forrest Solutions has created based on feedback from predominantly law firm clients. We do offer services to law firms and non-law firms, but we surveyed our law firm clients. And if you're interested in seeing the results, an overview of the results of that survey, we talk about the number of the dates that many firms have set to come back to the office, some of their documented plans, some of their undocumented plans, what they felt is most important from a health and safety perspective, and what's most important from a reorganizing the whole office. So you'll receive a link to that. So if you're interested, please feel free to download. There's no obligation. So on behalf of Forrest Solutions, thank you very much for your time this afternoon. And I believe our next webinar is at the end of the month. There'll be more details sent out about that. And we're doing that in conjunction with ARMA, the American Records Management Association. So should be an interesting one. Thank you very much for your time, and have a great rest of the week.
All right, thank you.